So today's set of notes looks at the federal court system. So this is really the last of the branches that you cover in Unit 2, having already covered the executive branch in the form of the presidency and the bureaucracy, having already covered Congress. Now we finish on the federal court system. So the first thing you need to know about the structure of the federal court system is the fact that ultimately the Constitution does not say very much about it. I said this way back when, but if you look at the Constitution, it kind of looks like a timed writing you did in English class where you had a great first body paragraph and then realized you'd run out of time. Because you've got Article 1, which deals with the Congress, and it is long, extensive, extremely well detailed. Then you get to Article 2, which is the executive branch, and it's a little less structured and a little less detailed, but still very richly detailed in both. And then you get to the judicial branch, and it's sort of like, judicial branch, we're going to have one of those. Constitution just says there will be one, that there will be a Supreme Court, and they make a passing reference to inferior courts that Congress may or may not establish, which of course they did. It doesn't say anything about how the Supreme Court will be configured, like how many members. It doesn't say anything about whether or not the Supreme Court will have terms. It just says in good behavior, which implies a lifetime term, which is what has become the standard, and makes sense given that the framers did want a certain measure of judicial independence. But it doesn't flatly say it. It says in good behavior. It doesn't make a reference in any way to what the responsibilities beyond a very limited statement about jurisdiction. So what it does say, even though it speaks to terms and speaks jurisdiction, is purposefully kept very vague. And again, it doesn't say anything about what courts will be established. That is left for Congress to do, and this is what they did. This is ultimately the structure of the federal court system. It is a pyramid. At the base of the pyramid, you have U.S. district courts. There are 94 of them, each have their own bankruptcy court. Bankruptcy is a federal process. Didn't know how many of you knew that, but yes, when you declare bankruptcy, you have to go to court and basically prove that you want the protection of the government in bankruptcy court. Because that's essentially what bankruptcy is. For those who don't know, it is a legal protection. It is that creditors, people you owe money to, cannot come after you because you have declared you do not have any resources for them. So there's one of those in every district court as well. So there are 94 district courts. There's one guaranteed in every state. And larger states that will have more federal issues get additional courts. So strangely, the state that has the most federal district courts is not California, even though they're one of the most populated states. It's New York, who is the fourth most populated state, but because the center of the financial community is in New York City, they're going to have more federal issues as it relates to particularly matters of economy and finances. So they have 4 district courts, we have 3. Most states have 1 or 2. Then the second tier up, or the middle tier, is what we call the U.S. Circuit Courts of Appeal. There are 13 circuits. One is just called the Federal Circuit. It's like a supervisory circuit. And then there's 12 regional ones. One, and only one, is located in a single place. And that is the place that has the most federal questions. And that, of course, I hope this is obvious, but maybe it isn't, is Washington, D.C. D.C. has its own circuit court. The other 11 regions are all done by what are called circuits that are multiple states. We are in the 9th Circuit, along with Oregon, Washington, Hawaii, Alaska, and I want to say the last one are Nevada and Idaho, or maybe it's Nevada and Arizona. But anyways, it's a regional circuit. And then, of course, you have the Supreme Court. So the way the process works is that virtually all cases start at that lowest level, and then you move up the pyramid. So let me give you a hypothetical to help illustrate this. Let's say, and this would never happen in real life because, 1, Coach Morrow has coached female athletes, and 2, the district wouldn't fight it if there was a dispute over it. But let's say that Coach Morrow's not the football coach. You got some old school conservative coach, and I want my younger daughter to play football. By the way, she had no desire to play football whatsoever. But let's just say she did. And it's some old crusty dude who goes, girls can't play football, which I don't know why I gave dude Southern accent, but I did. And so we say, you're denying our daughter her rights as a student to apply the educational course she wants. We're going to sue you in federal court. So we go to the local district court, which is here in Los Angeles, Southern District Court of California, and we file a lawsuit claiming that our daughter's rights under Title IX of the Education Act are being denied. And let's say at the district court level, we lose. We draw a judge who is every bit as old school as the football coach, and he says girls can't play football either. We lose. We retain the right to appeal. It's what's known as appellate jurisdiction up to the next level. And the next level is the circuit court, which the Ninth Circuit Court is located up in San Francisco. Fairly notorious for being a more left-leaning than not jurisdiction. So, given that fact, let's say when we appeal to the circuit court, first of all, that they accept it. They don't have to. That's an important detail. If the next branch up or the next stop up on the pyramid doesn't want to hear the case, then they don't. And whatever the last decision made, whatever was decided, stands. But let's say that the Ninth Circuit Court hears our appeal and they reverse. They side with us, the family. The school district would then have the option, should they so desire, of appealing to the U.S. Supreme Court. Now, understand, the U.S. Supreme Court is also entitled to choose their docket, and they may also choose whether or not to hear the case, and they may choose not to. So that is the structure of the court system. So that brings us to the question of jurisdiction. So the Supreme Court is very rarely, only in very small matters, which are specified in the Constitution, the only thing that is, where federal court cases begin. They do specify what is called the original jurisdiction of the court, and it's a very small number of things. Matters involving foreign ministers and councils, disputes between states over things like perhaps boundary lines or something of that description. There's very little that starts at the Supreme Court. Everything else is going to be heard from it on appellate jurisdiction. That is to say, on appeal from a lesser court. So you get, when I talked about the framers being vague, there you go. I mean, they say, oh, well, for most things, the court will have appellate jurisdiction. But remember, they didn't outline what those lower court systems were going to look like. Congress did it later. They did it, by the way, very quickly in something called the Judiciary Act of 1789, where they started to set up this lower court system. And it's been changed and refined ever since. So anyhow, 99+% of the cases the Supreme Court hears in any given set of years is based on this appellate jurisdiction. They are picking cases from those lower courts and determining that that's a case they want to hear before the United States Supreme Court, before the final nine, if you will. So this is the process. Most federal cases, as I said, including my hypothetical Kenzie playing football example, which again she had no desire to do, began in U.S. District Court. If we lose, we can appeal to the Court of Appeals. Court of Appeals, again, does not have to listen to the case. And in fact, they may well not do that. Okay? They may say, we decline to hear this case. And if that's the case, wherever the district court decides, that's what stands. That is going to happen because remember, you're starting with 94 district courts. Taking D.C. out of the equation, there's 11 circuits. So even though the circuits can hear cases in what are called panels, they don't have to have the entirety of the court hear it. 3 judges out of the 15 or so can hear it. Still, there's going to be a bit of a funneling effect. And that's certainly true by the time we get to the Supreme Court. Because if you lose at the circuit court, you have the option of filing for, and the reason this is underlined and italicized is it is a term you will need to know. It is a term called writ of certiorari. That's how that's pronounced, by the way. Certiorari is you're asking for the court to certify that they will hear your appeal. The court has to positively grant you your writ of certiorari. If they do, what they're saying to you is, yes, your case is one that we will hear. Now, understand that the Supreme Court's just one court and 9 members. Remember I talked about that funneling effect? Well, it magnifies like a lot when you get to the Supreme Court because you've got these 11 different circuit courts. A lot of cases at the circuit level come in 3-judge panels. And so by the time it gets appealed to the higher court, there may be thousands upon thousands of cases being sent to the Supreme Court in any given year. They can hear anywhere between 75 to 200 of them. So, I'm not a big fan of mathing, but you can do the math. They're not going to be able to hear every appeal sent to them. And in fact, they're not going to have the ability to hear most of the cases sent to them. So instead, what you get is the court hearing about 5 to 10% of the cases. So most cases asked to be adjudicated by the Supreme Court are cases that wind up staying at the circuit court level because the Supreme Court denies certiorari. So, for example, if you go back to the federalism section of our class, and we looked at how the Supreme Court, not the Supreme Court, excuse me, how the court system handled integration in Little Rock and in Boston. Well, the Boston case ended because the Supreme Court refused to hear the appeal of the all-white Boston School Committee. So they lost on the busing issue. Federal district court judge, a guy named Garrity, said that there would be busing in Boston. And then the circuit court confirmed that. They appealed to the Supreme Court. And the Supreme Court kind of says, nah, we're not going to hear that. So that can't happen. In fact, it has to happen. Because otherwise the Supreme Court couldn't function. Because they'd have thousands of cases and it's only 9 people and they only work 9 months out of the year. It's not built to handle thousands upon thousands of cases. It's built to handle 100 or so. Give or take 100 in either direction. So as I said, if the court refuses to hear that appeal, then the final court to rule on the case, the court of last decision, is the one who will see their decision stand. So hypothetical situation, we go back to my daughter playing football. Let's say that we win at the circuit court level. The school district appeals to the Supreme Court, and the Supreme Court decides not to hear the case. Then it is official, and we, my family, has won. Because there will be no further litigation on the matter, and the last court to decide on it sided with us. Okay? All right. So let's talk about what the federal court does when they make decisions, because it is counter to what I think a lot of us think of when we think of courts. When we think of courts, because we've watched a lot of movies or we've watched old TV shows like Law and Order and whatnot, we think it's like, will the defendant please rise, and a jury and all that. That's not the way the federal courts work. The federal courts work off of what we call opinions. So when the Supreme Court announces a decision, the first thing they do is they issue a majority opinion. So a majority opinion is the official opinion of the court, the official reasoning. And in the case of federal law, the reasoning is what really matters. Yes, it matters. So like if they're going to adjudicate gay marriage, it matters whether they say gay marriage is constitutional or not, for sure. But what really matters is the why. Why are they arguing that it is constitutional? Why are they arguing if they decide against it, why it is not constitutional? What prior cases factor into their thinking? What constitutional principles do they employ? That's why the majority opinion is so important, because why they ruled a certain way will guide future decisions, right? Because the court generally relies on past decisions to inform their future decisions. They don't always do that, of course. Plessy gets overturned by Brown. Betts versus Brady gets overturned by Gideon Wainwright. Brown, so I already used Brown, sorry. Miranda overturns previous criminal rights cases where they said, he confessed because he got beat, but he got what he had coming or whatever. I mean, so yes, in fairness, for sure, the nature of these court cases is that where they really become super duper relevant is when they overturn previous precedent, but they generally don't. So a court saying why they ruled the way they did, right? So for example, the most controversial recent case of our times, and just to give you a heads up, this is being recorded in May of 2024, is the Dobbs decision from a couple years ago that gave states the option of banning abortion, which overturned precedent. It overturned Roe versus Wade from 1973. In that Dobbs decision, the court laid out why They were reversing Roe. So if there are future challenges, not previous, if there are future challenges, then you can feel very assured that some more conservative justices and judges will employ the decision making in Dobbs to try to justify future restrictions. Likewise, you'll see future judges employing Roe or employing latter decisions that confirmed Roe. So that is why the majority opinion matters. But it's not the only opinion that gets registered. There's also something called a concurring opinion. Now, in a concurring opinion, a judge will say, yes, I agree with the majority that this side should have won, but I have a completely different legal reasoning for why I think they won. Happens actually with some frequency. So what that does is issues up an entirely different level or different layer, if you will, of logic for why the court ruled the way it did. And those can also be employed by future courts to say, oh, hey, this is really important. That, so-and-so thought this was why this is constitutional. And then there are the dissenting opinions. Dissenting opinions will matter a great deal when it comes time to overturn an old principle, like segregation and Plessy, like not letting criminals have a right to an attorney and being overturned by Gideon. The logic of those groundbreaking decisions, Gideon and Brown, came from the dissents that were issued decades earlier. Now, as you saw in the film on Gideon, when we watched it if you had me for history, we watched it because it was part of the civil rights section of the class. As you will see a little later when we look at civil rights and civil liberties a little while down the line, ultimately, the guy who wrote the dissent on the major case saying that states didn't have to provide lawyers, a case called Betts versus Brady, the guy that wrote the dissent in his first year on the Supreme Court is the guy who will write the majority opinion 26 years later overturning it. A guy named Hugo Black. That obviously did not happen in the Brown case because that was 58 years after Plessy, but they went to the major dissent in Plessy, which was done by Justice Harlan. And the irony of Plessy, by the way, for you historian geeks in the room, is that Justice Harlan came from a slaveholding family. He was a Southerner. And he's the one that really went after the institution of segregation. He was the lone dissenting vote. It was 8-1. What's even more crazy is that the justice who wrote the majority opinion and basically said separate but equal is perfectly constitutional and a generous compromise for the ravages of Reconstruction was from the cradle of abolitionism. He was from Massachusetts. So sometimes you just can't predict these things, I suppose. But Harlan's dissent becomes a major, major factor in how the logic will be presented to overturn Plessy 58 years later. Last slide is how they choose a case. Now, first of all, let's start with the simple thing. The court bases what they want to hear on something called the Rule of 4. 4 of 9 justices want to hear a case. Well, it's probably not going to be a 9-0 decision. It's probably not going to be a landslide. So they're saying, hey, if 4 of us want to hear it, we think there's something here we need to know. And that's just shy of a majority, of course. So usually they choose to hear cases for 3 different reasons. Reason number 1 is they think that they may interpret the issue differently than previous courts did. Reversing precedent. This is the court in 1954 saying in Brown that they think they're going to overturn Plessy. So they want to hear this case because Plessy is on the block, right? Or, Gideon Wainwright in 1963. Or Dobbs in 2022. These all apply here. Sometimes they do, of course, the court does issue 9-0 rulings. When they do that and affirm something 9-0, they're trying to put a stamp on it. Okay? So they want to emphasize the court's support for a particular view, so they take a case so they can kind of uniformly and unifyingly say, no, we disagree with this. And they may do that on things like one of the cases they took in the 2020 election. Went 7-2 against Trump. That was the court pretty clearly saying that they thought their legal argument in that case to throw out a bunch of ballots was invalid. They didn't have to take that case, but they did. And then, because they didn't have to take a case, by the way, because the circuit court had already agreed that the ballots in question, which was in Pennsylvania, shouldn't be thrown out. The Supreme Court took the case so that the biggest court in the nation could say, yes, we agree, no, they shouldn't. And then, last but not least, they think there's genuine disagreement among court members. A lot of Supreme Court decisions are 5-4 and 6-3. The Dobbs case was a 5-4 decision. So that's another occasion where you might see the Supreme Court take a case is because they genuinely don't know where they're going to land. That does happen. And it happens in a way sometimes where they make a decision that everybody thinks is going to go the other way. That's happened on a couple cases recently. There was a state case about whether or not you could fire trans people just for being trans, if that was within the right of the employer to do so. And everybody assumed, given that the court had 3 appointees from Trump and was 6-3 conservative, that state law allowing people to fire trans people would be upheld, and it wasn't. When the state of Alabama tried to defend its racial gerrymander this year, everybody assumed the Supreme Court would let them do it, and they did not. So there are examples where the court, very closely, 5-4, 6-3, will kind of defy conventional wisdom. And so the only way you're going to know if they're going to do that is if they take the case. Okay, so that is it for kind of the basic nuts and bolts of the judicial branch. Hopefully this helped you out a little bit, whether this is you hearing it prepping for an AP exam or this is you hearing it in class before the unit exam a year or two from now, or whenever it's lost to history, if you will. Another set of notes, which I'll be putting together here in a minute, is looking at the other big issue in the judicial branch, which is the notion of how justices make decisions, the idea of judicial restraint versus judicial activism. So that'll be around here somewhere. Take care, everybody.